Good morning. Are you Eric Segrest?
Yes, ma'am.
And this is cause number 25, DCCR 1836. Mr. Segrest is charged with burglary of a habitation. And what is the announcement?
Judge, this was one that we had reset here from a few weeks ago where Mrs. Smith was trying to reach out to the complainant in regards to this case, some paperwork that she supposedly had came and filed with the DA's office. To date, my understanding, he has not been able to get with her. I've tried to call her, but hasn't gotten any answer. I've got a separate number that supposedly is supposed to be good to reach out to her. I've given that to Mr. Smith. And of course, we're asking for a little time to see if we can do that. I've talked to my client. He did want me to ask about possible.
And right out the gate, we've got strategy in motion. When the complainant can't be reached, that weakens momentum for the prosecution. But here's the real chess move: bond reduction. If the state's witness is ghosting, does continued high bond really make sense? Or is the defense quietly building leverage? Let me know in the comments. Smart timing or long shot gamble?
Of a bond reduction.
Well, let's do this because that would make sense if you can't get in touch with her. I'm going to reset it 1 week. Mr. Smith, see what you can do with that new information, and let's get an announcement next week. If for some reason you can't get in touch with her, but the state's going to proceed with the case, then we'll talk about a bond next week.
I'll file a motion to that.
Perfect. Thank you. All right. We'll see you next week. All right. Will your client waive the formal reading of the motion?
He will.
I didn't already ask that. Sorry. This is cause number 25, DCCR 0895. And Mr. Douglas, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony. And that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation in count 1 only by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025, which was the same date of your last hearing. And so, is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes, ma'am.
And because it's actually true?
Yes.
Okay, this is where things turn serious. A plea of true in a probation revocation is basically waving the white flag. There's no trial on the violation. Sentencing is now fully in the judge's hands. And when the violation involves jail misconduct, that's like breaking rules while already asking for mercy. Was this honesty the best move, or did he just hand the judge a blank check?
So he never even made it.
I know. That's just. And I guess once you did that, you decided, screw it, I'm going to do whatever I want because I already know I'm going to get in trouble because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
I got no problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them? Even though you know you're going to get written up and go to prison for that?
And that right there is the moment the courtroom shifts from procedural to personal. The judge isn't just listing violations. She's calling out behavior that torpedoes credibility. Jurors don't hear this, but judges remember it. Every outburst, every report, every poor choice stacks up. So here's the question. When someone keeps sabotaging themselves, is prison punishment, or is it inevitability?
Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm going to accept this agreement. Mr. Wara, in clause number 24, DCCR 2344, the state is elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from October 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wara is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with the
10 years. And notice how methodical that delivery is. Once a plea agreement is accepted, it's locked in. The deadly weapon finding? That's huge. It affects parole eligibility and future firearm rights. This isn't just a sentence. It's a long-term legal shadow. Do you think 10 years was fair for aggravated assault with a deadly weapon? Or too light? Drop your take below.
that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in this case. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. There you go. Good morning. Are you Jonah Johnson?
Yes, ma'am.
This is 25 DCCR 1775. Mr. Johnson, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from August 31st of 2025. And what that means, sir, is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
Can you check if there's any of his in that pile? I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have
Wow. He just rejected 15 years, knowing trial exposure goes up to 20. That's confidence or risk tolerance on another level. Trials are unpredictable. Juries can be sympathetic or unforgiving. So now it becomes a gamble. Bet on yourself or lock in certainty. If you were facing that range, would you roll the dice?
your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Ms. Holmes has been appointed to represent you, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Ms. Holmes, you are released. Mr. Johnson, we will appoint someone today. They should be out to the jail very soon to begin preparation for trial. All right,
Yes, ma'am.
and there's none. And just because I get on to everybody for having incident reports, thank you for not having any incident reports. I mean, right? I feel like I need to, seriously though, it can affect your case. It can affect how the DAs look at your case. It can affect how a jury looks at your case. Continue doing what you're doing in jail, following the rules, because that's only going to benefit you, okay?
Yes, ma'am.
All right, you can go back with the bailiff.
All right.
Good morning. Are you Derek Butler?
Yes, ma'am.
This is clause number 25 DCCR 1653. Mr. Butler is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, there is some media attached to this case that I need to review with my client.
Okay,
I just need a little time to do that. I've talked to Mr. Smith about the issues I'm having before it's through with that video.
okay,
And so we just need a little time so we can get that taken care of.
okay. So you're having trouble pulling it up.
Well, it's not that, it's just a factual issue.
Oh, gotcha,
resulting
okay.
From,
So do you need a normal reset or just maybe a little shorter?
actually a little short. It doesn't have to be a normal reset.
Let's do about 3 weeks.
Yeah, that'd be perfect.
And so, Mr. Butler, Mr. Lewis will be out there soon, I'm sure, to go over all of that discovery, and then you guys will be able to make a decision and have an announcement at the next court date. All right, thank you.
Thank you, Judge.
Good morning. Are you Derek Corbin? This is cause number 25, DCCR 1659. I'm going to take judicial notice of the court's file, Mr. Corbin's case. Mr. Corbin was evaluated for competency to stand trial by Dr. Rapine, received that report dated January 20th of 2026. And the finding in his report is that Mr. Corbin is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Lewis?
Not from the defense.
Mr. Nichols?
No, Your Honor.
Then at this time, based on that report, I will find that Mr. Corbin is competent.
Competency findings don't mean someone is mentally healthy, just that they understand the proceedings and can assist their lawyer. That's a legal threshold, not a wellness stamp. And when mitigation records start coming in from family, that signals negotiation territory. This phase is quieter, but it's where cases are often shaped behind the scenes. Do you think mental health mitigation should reduce sentences more often?
Stand trial. He is charged with the offense of robbery. And Mr. Lewis, what is the investment?
Judge, since we've gotten the evaluation back, Judge, I've been able to start one talk with Mr. Corbin, look at all the files. There is still some mental health issues that we're dealing with. I've gotten some records from his family that's come in here recently that I'm going through basic mitigating circumstances. But I do want an opportunity to talk about those with Mr. Nichols.
I'll just do a normal reset on Mr. Corbin's case. Mr. Corbin, I'm going to reset your case for about 3 or 4 weeks. Mr. Lewis will go through everything that your family's provided, talk with Mr. Nichols about that, and I'm sure he'll be out to visit with you about what your options are at that point. Okay? You can go back with the bailiff. Good morning. Are you D. Antonio Riggs?
Yes, ma'am.
This is 25 DCCR 0975. I am going to take judicial notice of the court's file, Mr. Riggs' case. Mr. Riggs was evaluated by Dr. Hamza for competency to stand trial. I received that report dated, let me get to it. The examination date of January 27th of 2026. The finding in his report is that Mr. Riggs is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, not from defense.
No, Your Honor.
Then at this time, based on that report, I am going to find that Mr. Riggs is competent to stand trial. Are you ready for an announcement or do you need some time on that?
A little, Judge.
Okay. I'll just do a normal reset. If something happens and you want to move it up, just let us know.
Okay.
Mr. Riggs, Mr. Lewis will be out there to visit with you about your case and what your options are, and we'll get an announcement at that next court date.